Hi, I'm Mark Stevens, author of Government and Died, the website, of course, markstevens.net, the radio show, the No State Project, live every Saturday from 4 to 7 Eastern Standard Time on the LRN.FM Liberty Radio Network, and also live every Wednesday, so from 6 to 7 Eastern Standard Time. So you got 4 hours of Anarchy Radio. And also 4 hours in which to confront me, which we had last week, which was very surprising. ICBM catcher called in. Definitely check out this show. A lot of really good stuff. I think he made a complete fool of himself. But hey, you be the judge of that. No one yet has actually called in or left a message, a comment that he debunked me. But hey, it's still, we'll give it some time. It hasn't been up that long. It's only been up a couple of days. So we'll see. So what I want to get to today is because I think too many times people are intimidated by these prosecutors because, they're defending against an attack. And it's one thing to go against a police officer in court. It's less intimidating than the street because, of course, he is not going to necessarily pull out his gun. And you can maybe have a discussion there. But lawyers, they have advanced university degrees. Prosecutors are professional litigators. They got more experience. Don't let this fool you. Because no amount of, as the confrontation with Scott Bales, the Chief Justice of the Arizona Supreme Court, will show you, no amount of education and experience is going to help you if your position has no merit, if your position has no facts, no proof, and no logic behind it, where the only thing you can do to support your position is, well, we'll put you in prison. I'll just hurt you. How about that? I'll hurt you. So I want to go through how easy in this video how easy it is to pull apart this garbage that prosecutors provide. But I want to point out too, and this is in the article, keep in mind this very reason, what we're going to go through, the garbage you're going to see from an actual prosecutor, and I've done this a number of times, and I don't do it too often because our position is so strong. The only thing prosecutors can do is either keep their mouths shut, which is typical of what they do. They usually just keep their mouth shut. You can accuse them right to their face of being a criminal. They're just going to let the judge do the talking and the threats. And that's because, when they do respond, it's typical garbage. I mean, it's usually just, and this is what we're going to go through here today, strawman crap. So when you get if you get a response from a prosecutor, just know it's going to be trash. It's nothing to be intimidated about. You just have to look at it logically. Look at the logical fallacies. Is he addressing the actual argument? So this is from an actual prosecutor. His name is Gene Barrett. He's in Ohio. Let's see. I just want to show that's where exactly it is. Look, I didn't want to do so much editing, so I'm not going to show the caption. But I am going to show that it's a real prosecutor. He's right there in Ohio. And let's go through the straw man. Let's put it up here. Where is it? Where is the red arrow? Okay. Defendant contends that this honorable court cannot obtain jurisdiction over him without his consent. Defendant asserts that he does not voluntarily submit to the court's jurisdiction. Rather, he is participating under threat, duress, and coercion. Generally, all Ohio courts have jurisdiction over violations of Ohio law. I'm not going to read the citation. We addressed this jurisdictional argument in St. Paris v. Galuzzo. With respect to personal jurisdiction, many courts have addressed and rejected arguments similar to the one raised by Matthews. Matthews is not actually, it's this other case. It's not who I'm working with, i.e. that a citizen must consent to the jurisdiction of the court. This court and others have found that consent is unnecessary and irrelevant to a court's jurisdiction. When have I ever said that a citizen must consent to the jurisdiction of the court? This is not the actual argument that was raised. That's why we call it a straw man. So we go to your logical fallacy is, and there it is. It is by exaggerating, misrepresenting, or just completely fabricating someone's argument. It's much easier to present your own position as being reasonable, but this kind of dishonesty serves to undermine honest, rational debate. See, you misrepresented someone's argument to make it easier to attack. See, that's not what's actually happening here. What is actually going on, and what he was accused of, was arguing without evidence. That's the basis of our claim for prosecutorial misconduct. Now, it does say that he's participating under threat, duress, and coercion, but that's not his argument. His argument is not that he is. That's just the truth. That's just an observation. The argument is that the prosecution has completely failed, and we know this through the record itself and through the lack of response to the Brady request and the discovery request. They have failed to present a single fact and to support their claim that a written instrument from 1803 actually applies to us just because we're physically in Ohio. So he completely fabricates the actual argument. Defendant did not contend. This is completely dishonest. But hey, we're talking about lawyers. See, it says right here, a lawyer shall not, this is the, you can see right here, it's Cornell. It's the Ohio Rules of Professional Conduct. A lawyer shall not bring or defend a proceeding or assert or controvert an issue in a proceeding unless there is a basis in law and fact for doing so, which is not frivolous. So what he's done here is he's lied, saying that the judge cannot get jurisdiction over him unless he consents. Then he goes on to cite all these things down here that are completely irrelevant. So you can just completely disregard all of this because he's not addressing the actual issue that was raised. There's none of this is relevant. Absolutely none of it is relevant. Despite his argument, defendant has failed to indicate in any manner why the trial court lacks jurisdiction. Yeah, it's because you don't have any proof. You are arguing without evidence. He says, without any evidence to the contrary, the defendant has failed to demonstrate that the trial court lacks jurisdiction. Isn't it interesting? I thought jurisdiction was not an issue of evidence. I didn't think you needed evidence on an issue of jurisdiction. It was purely a theoretical issue of law. Why is he saying that we would need evidence if evidence isn't required? You see, this is why evidence has to be required, why logic dictates you have to have evidence and logic to support your claim, or there's no merit to it, because you can get into these pissing contests where you're just arguing opinion. And how are you supposed to determine which one is true if it's neither one of them has to be based on any kind of evidence and logic? Please. It just reminds me of Patches O'Houlihan from, Dodgeball. It's like a bunch of retards trying to hump a doorknob. That's exactly what you get when you're getting around trying to just see which arbitrary opinion is true. So don't be intimidated by these guys. This is another thing that he does. According to Rule 602, a witness may not testify to a matter unless evidence is introduced sufficient to support a finding the witness has personal knowledge of the matter. He then goes on to cherry pick and completely disregard the personal knowledge matter by quoting 601 that is a general. This is a general rule that comes before 602, which is specific. This is general. And it says that everyone, unless subject to these rules, everyone is competent and qualified to testify unless disqualified by these rules. Well, Rule 602 is there for a reason. That disqualifies someone who doesn't have personal first-hand knowledge. And it's not saying that, how can the police officer have personal knowledge just because he was there? Of all the matters that he's testifying to, just because he was at, no, come on, give me a break. Just don't be intimidated by these people. You can see that most of this crap, if not all of it, is completely irrelevant. Don't be intimidated by them. Just go through this, apply basic principles of logic. Whether they think it applies in a courtroom or not, I don't give a damn. It's dishonest to the core, because what we can do is we can go to their legal logic and we can say, did Barrett bring or assert an issue in a proceeding that was not having that did not have a basis in law and fact? Did he do that? Did he violate the fundamental rule? Did he argue without facts and evidence? And if you go through his trash, he's clearly trying to make a point that his citations, not evidence, that his legal citations qualify as evidence. Yeah, right. So what he's doing is he is clearly arguing without evidence. He's trying to make a point that he can argue and support his argument with more argument. That's crap. No. Argument is limited to the facts and evidence, which is why he has to resort to the tired old straw man and lie about the position. So again, if you're defending against one of these attacks, don't be intimidated. Use a cool head. Examine it. I'm more than happy at markstevens.net to help review stuff like that. You can always call into the radio show, and you can get help with that. Or you can just go and apply basic principles of logic that's available online. And we have a lot of the objections and logical fallacies at markstevens.net. If you go up to the markstevens.net wiki page. So if you think my analysis is incorrect here, if you think I got something wrong, if you think I'm being unfair about this prosecutor, Gene Barrett, then, hey, we got 4 hours of Anarchy Radio every week. Feel free to call in and show where I got my facts wrong and show the flaw in the logic. Till then, my name is Marc Stevens.